late coming. We don't want employees to be coming late because it affects us. We are losing out. If you're attending to clients, no, employees, when they come late, they don't attend to clients. If he's talking on the phone during working hours, you explain how, and you sit down, you talk to your employees. We can't allow you to have a phone whilst you are working because the clients will think you're not paying attention to what you're doing. And when you do this, it doesn't leave a good reputation. But in another institution, talking on the phone it's not something that is not acceptable. It's quite acceptable. It could be part of your work, or it doesn't really negatively affect the operations. So those are some of the issues that we need to look at when we are defining. So it's not, there's no way of saying this is the clear cut of what is the behavior which is not accepted in an institution. But we need to sit down and understand what are we doing. But we should ensure employees are updated, you sensitize employees, and it's not once off. You can't just have employees that I recruited this employee 5 years ago. I have Mr. Kabanda who joined me in 2013. No, remember that we spoke to you in 2013. Why not sit down and remind the employee the way we remind them of the targets? Yeah. So that's what I would say on that aspect, Patricia.
All right, thank you very much. Mr. Kabanda, let's talk about some implications of a summary dismissal.
Yes, so if you summarily dismiss someone without having followed the procedure, first of all, when the person is summarily dismissed, you need to inform labor office, and after that you also need to make sure that you make all the payments that are due and payable. If you didn't follow the procedure, the person can actually sue you, like we have said, and you end up now paying for, sometimes the courts may give 12 months or 6 months or 42 months where you're paying a compensation, or it can be any amount that the company may, the courts may deem to be fit. And that is why, to avoid unnecessary lawsuits, that's why we're talking today about the need to create a proper disciplinary code. So in the disciplinary code, what is important is that you need, first of all, like we said at the beginning, what are the principles you are using. Then in the same disciplinary code, we need to see and demonstrate who is going to be responsible for what, like what he said earlier on. Why that is important is because if you don't define the responsibilities in the disciplinary code, then you have anybody firing anybody giving warnings. So it needs to show, okay, a verbal warning will be issued by an immediate supervisor, and even when we talk about verbal warnings, there is also a form that employees can be made to sign, which is called the verbal annotation form. Why is that important? Because if somebody was just talked to and there's no record, and I know this is where there is confusion with employees and employers. So the employees will say, no, but why am I signing this when it is verbal? No. The issue is that it's a verbal annotation form. You need to take a record that indeed today or this day you were warned about something. Because what happens is that sometimes people come and refuse. Some will even swear on the graves of their grandmothers. Nobody ever talks to me about this. So it's important that there is that documentation of even those verbal warnings, written warnings, and who can issue a written warning. Sometimes it's issued, depending on the disciplinary code, it will be that written warning, for instance, or can only be issued after a disciplinary hearing, and it's issued after the committee has heard the person. So in some cases, in others will put it under the supervisor. So it needs to be very, very clear, and that's why that document, we have said before, don't just pick a document from somewhere and say we are also applying this. No. In that same document, we also need to make sure that when we now start looking at the schedule of offenses, so in the disciplinary code, you're going to find a place where now you put the schedules. So to show you first breach, second breach, third breach, fourth, and so on. Now, like what Stan was talking about, you need to show what are the offenses that fall under first breach. Okay? Sometimes it's a verbal warning. From the verbal warning, then it moves to written warning, then to final warning the third time, and then maybe dismissal. Some cases are so severe that they will not even give you the first, second, third, fourth breach. So if it is, for instance, cases of theft and so on, the case might be immediately find you guilty, is instant, the so-called instant dismissal. So the disciplinary code needs to be very, very clear in terms of what will be in that schedule of offenses. And when we talk about offenses, it's also important to understand that from the company's perspective, there are two things that the principles that apply. And because these are the problems that we see a lot of times in companies where you pick criminal offenses, you want to throw them in the disciplinary code. The disciplinary code, remember, it's within the institution. So what then that document should have should be offenses that you can work on the principle called the balance of probability. Balance of probability. So that's what you use within the company. That is, I'll ask myself, did Patricia actually do this? Okay, do we believe, based on all the evidence with us, that Patricia could have done this? It's balance of probability. When we talk about criminal offenses, there you are using another principle, which is the proof beyond reasonable doubt. Now we have to prove beyond reasonable doubt that indeed you stole. And that's why we always tell managers and business owners or institutions that you need to separate these things, because criminal offenses is proof beyond reasonable doubt. Meaning that it puts a lot of responsibility on the company, on the employer, to prove beyond reasonable doubt. And again, you see, I'll give you an example. I joined a particular company in 2015. And when I joined them, there were a lot of employees, 1,600. And the company was in construction. So when I was joining them, I found that they had fired some 10 guys because they were suspected of stealing fuel, other cement, and so on. And so they went to court. Now, based on this principle, they lost the case. And now you have a group of 10 guys, they come back to the company, they are free men.
Yes.
And now within the company, you are saying, no, these are thieves.
Yes.
And some foremen and supervisors start to treat them like, no, don't even give them work, because these ones are thieves. No, but they were found not guilty. So the problem there lied in the fact that the way they were treating things, they were not separating these two. So anyway, we went in and cleaned the process. So, I'll give you just an example of even the so-called theft. Theft itself, I know it is a big issue in a lot of companies, and you find this nice line in a lot of disciplinary codes. No, you have stolen. Yes. So the challenge with that is theft. You now need to start with proving beyond reasonable doubt that this guy actually stole. So what happens what we advise companies when looking at the disciplinary codes? You break this one theft into 3 different charges. Okay? One is removal of company property without authorization. Yes. 2, being found in possession of company property. And 3, conspiring. Now, well, what this does is like this. You can have Kabanda, Chipata. The guy, sometimes what they do, it could be, for instance, in the mines or whatever place, or even in any company. The person takes the company property, they remove it, and sometimes they throw it over the offense. Yes. Okay? They throw it over the offense. So, when you charge them with theft, as you can see, I'm clean, they didn't find. Oh, okay. Now, we are not going to say you stole. All the facts, if we catch someone and they say, no, yes, I was working with Kabanda. Okay, Kabanda, you are the one, for instance, those guys who do with the workshop or the stores. You removed. We didn't catch with the thing. But you removed. So they will still be hammered and can still be dismissed. Yes. You find sometimes as you are investigating, one of your employees, you find they even have their own storage. Yeah. They are getting things from this side. It could be maize, it could be, if you're in the mine, drill bits, or whatever it is, company property. So, and unfortunately, sometimes these company properties, they come with numbers or codes. So you can actually say, these are not your things, they came from the company. So that person who is now found with those things will now be charged for being in possession. Wow. So we are not saying you are the one who removed. What we are saying is, Baba,
You're in
You
possession.
are in possession. Even how did these things come about? So now they start telling you the whole story.
Yes.
Okay, and sometimes you find that managers are involved in the process, and that's why we say to employers, don't jump and become emotional. No, fire this one. Take your time, do the proper investigation. So you even hear, no, actually it was the boss, what he did, he was this, not my supervisor. So now that one, because the boss is not, so this one will now be hammered with the conspiring. So you actually clean up the whole system and the whole group who are trying to now do wrong things in the company. So what is key is taking your time. So the disciplinary codes we're talking about should allow for due processes to be followed. So what that means is that once you observe something is going missing, or someone is not performing in line with the company, or they are behaving contrary to the requirements of the company, you treat that stage as the first stage. You are suspecting, okay? So that you also sit down and look into those issues. The next stage now is to now carry out the investigations. And that could even be on a performance issue.
Yes.
It's not just on behavioral issue when we're talking about theft, because we know theft is the biggest issue. But it could even be on performance or other things. Investigate what could be the problem. Because sometimes even an employee, even a very good performing employee, they could be going through some personal challenges. And all of a sudden, they are not performing in line with the requirements of the company. Or they are not behaving. You find some guy has just been dumped. So even when he wakes up, he doesn't even care now whether he reports for work or not. They are going through so many challenges, or they have a bereavement, somebody has died, or they just have a problem with the immediate supervisor or someone within the company. It could be so many things. Or some they could simply become sick, but they are not sharing. So it's important once you suspect that somebody is not behaving or performing in line with the company, try to find out what exactly is going on, so that then from there, the third level now is where you now start to now ask, okay, if from your investigation you find out, okay, there's actually no issue here, you drop the cases. If you find that, there's actually an issue here, then at that point, like I was saying when you're talking about the processes and steps, you can now escalate the matter now to say, okay, because sometimes after you do your investigation or you sit down with people involved, that's when it leads to what he's talking about. Just maybe it's a mere warning. Sometimes the person requires actually further training if it is a performance issue, where you say, okay, maybe we need to give them maybe 6 months performance improvements. If it is a behavioral issue, you give them some verbal warning and say, look, change, further to which this and that will happen. And if it is a serious issue, which now needs to be escalated to a hearing, then at that point, of course, the person needs to be charged formally. Now, going back to that document he's talking about, when raising those charges, you need to raise charges in line with the disciplinary code. So you go into that document, check page by page, what is it saying? Which offense has this person actually committed? Because sometimes people you go and say, no, I think this is an offense, late coming, or this. And it is not even reflected there. It is helpful if you check, unless an offense was not provided. And again, a lot of disciplinary codes have a provision there, which allow for you to raise a charge if it is still not in that document. But in many cases, the document should at least have a lot of the offenses, so that you're now saying this charge is being raised because you have committed an offense, or you are being suspected to commit such offense contrary to clause X, Y, Z of the disciplinary code. And then you allow the person now to respond. In some cases, some companies give 24 hours, others they give 48 hours, others 72 hours, depending on the company and the disciplinary code. Allow the person to respond. You read through, you can do further investigations, check witnesses, and if you see, okay, we still need to go forward, then you now go for the actual disciplinary hearing, where now in the hearing, you need to have, it's one thing we will talk about in detail, where we should have an independent body to actually look at this case. So you need to, so the HR, and again, this is where problems start with HR, because when the boss said, this one,
Yes.
fire, you know, because sometimes the boss is moving around and they find, I found that one was sleeping, eh?
Yes.
I don't want that person. But that's not what your disciplinary code says. It says give them a warning. So sometimes, and we have to speak to CEOs and business owners, managers, understand what your own document stipulates. Because sometimes they come with so much pressure. No, I saw him going that side. That is restricted. So what was it? Fire. So now, it's just instruction, fire,
Yes.
fire. And you are forgetting now, because HR sometimes also is in a space where they can't even talk to the bosses.
Yes.
But again, our advice is, as HR, go back to the boss and say, okay, boss, we received your instruction. We're looking at it this way. Sometimes as HR, you set out even your approach, and so that your boss can also get some comfort that, okay, you are still dealing with the case, and educate them also, because it's not their job. They are running a company, so it's not their job to understand everything. But you should, if there is an HR person in the company, that HR should inform both the manager and the boss that, okay, this is what we are doing, because in many cases, for the people up there, the case is closed. Why are you delaying? You know, it takes 1-2 weeks, and I told you already. Why are we not moving? No, but it shouldn't be like that. It should be a situation where you look into the case, make sure you have all the facts with you, because remember, we always say, anytime you're dealing with a case, your mind should be sitting in court. What are the things you will produce in court? So that's why, as HR, we advise that the HR should pull back from all the emotions, start to make sure that the investigations were done, you have all the facts with you, all the statements, so that even when the disciplinary committee is sitting, it has facts with it. And they will be looking at those statements and the facts before it, so that even when the person is brought in, they give their statement, then they can either find that person guilty or not guilty. And then they'll make that recommendation, and then the letters are then afterwards issued to the person, whether they are fired or not, if they are found guilty or not. And then there will also be a procedure to allow for that person to also even appeal. And that's why, because of all these things we are talking about, it's important that the bosses are kept out of the... Yes. Because remember, if, for instance, a CEO of the company comes in and now, and this does not apply to the managers who are reporting to the CEO, but we are talking about a CEO dealing with a case of a junior officer.
Yes.
No, I found him outside. Is the CEO is even the one raising a charge? So now, remember, after the process, dismissal, whatever happens here, there is appeal. So if this person now does not have anywhere to come and appeal, what have you done? Yes. So there has to be, that's why we're talking about fairness, the process, what you put in the disciplinary code, the document we've been talking about, and also what you implement on the ground. You need to make sure that there is some level that allows for the person to escalate matters to higher officers, and thereafter, if the appeal goes through, the person can, the appeal committee, which is also independent, it shouldn't be having people who sat in that in the disciplinary committee. Yes. It should also be a different body to look at the case and then say, okay, we also go with what the disciplinary committee found, or no, we think maybe some processes were not followed, or there's some other facts before us which make the appeals committee to make a different decision, which could involve also even the person being brought back or another decision being made. Or they say, go back and start the process. So there are a lot of things that appeals committee can look into. Beyond that, the person is fired, if the summary dismissed, they are free to now approach labor office and the courts to look into the case in case something was not done properly within the company. So it's important that everything is looked into in totality, so that what the company is doing is in line with the due processes.
All right. Mr. Stanford,
Yes.
So you did talk about the process to take before summary dismissal. So if there's a situation where the law isn't followed correctly, what are some of the implications?
Okay. So if a dismissal contravenes the provisions of the law, the outcome is taken to be unlawful. Anything that is found to be unlawful, it means the decision that you made does not stand. So an employee who feels the decision of the company or a disciplinary hearing has contravened the provisions of the law, or a company did not follow the provisions of the law, can actually bring out those issues. And those are some of the issues that employees can bring even on appeal. So this is what employees are advised. So when you sit down, for ease of understanding, we go back to section 52, which talks about the right to be heard. An employee is alleged to have committed an offense. And then an employee has been approached by the company that this is what you did. And an employee says, no, I never did it. Then the company said, no, we stand our ground. You did it. And then they dismiss an employee. An employee has got the right to appeal. If the people who are sitting on appeal insist that because of what has been submitted, we are sustaining the decision which was area met, and the employees told, no, you remain dismissed, the employee should challenge it on the ground of it being unlawful dismissal. What follows if the employee wins is what was explaining. The employee will be compensated depending on the factors that are going to be considered. But there are also instances. Remember, we are saying a dismissal could either be questioned because it doesn't follow the law, or it hasn't followed the processes that you provided for in your disciplinary code. A decision will be found to be wrongful. Just that sometimes employees will use different terminologies and they need to sit down and consult. Sometimes we even have the grounds to challenge the decision, but we don't know what are we pursuing. So sometimes the decision will be wrongful because the company itself has not followed its own decisions, its own processes. And that's what the court will be looking at. You said this employee before being brought before a disciplinary hearing will be given an opportunity to exculpate. That you are going to hear this case within so many days, but you have taken months. Why did you take that long? Your own processes have not been followed. So those are the implications with regards to people not following the law. And some of them could be issues of the substance itself. Imagine somebody being dismissed because they are expecting, we are discussing maternity leave. The law says you are protected. So if you take out anything that is to do with discrimination, in future I'll be discussing even issues to do with union membership, but we can even bring it out right now that an employee cannot be dismissed for the fact that they are unionized or have opted to join a union. They will challenge that. So employees, once they start to follow through and learn what is in the law, what is in the procedure, they can protect their rights. And they will even avoid and challenge whatever decisions that management is making, which is not favorable to them. So those are the critical implications that are there with a summary dismissal which is effected and does not comply with the law. That is unlawful and can be reversed either at appeal or by the courts of law. Some institutions who've got proper disciplinary codes and which have provided for independence of the committees, like Mr. Kabanda said, when it goes to the appeals committee, at that moment, remember, all the emotions have settled. The appeals committee now will sit down and say, no, you guys, do you know what you did? Are you aware of where you're going? Because now they start testing. It's like a pre-trial before you go to court, appeals. That's why if there's independence, the appeals committee now will stand and go to management and say, no, yes, there was this decision which was made, but we feel whether it's supported by the majority or not because of AB. Sometimes the substance could be okay, but at times because the process is not followed, the law is not followed. Doesn't mean that if you found somebody in possession of the property or of company property, then you say you are going to go ahead. But should bear in mind that other than the substance, we must respect the law, what it says on how we should handle it, and the processes that we've confirmed and committed ourselves that we are going to follow through. Yes.
Right. Mr. Kabanda, what are some of the steps which must be followed before effecting a dismissal?
Yes, so the key steps to be followed. First of all, a company also, like we've said, having that disciplinary code in place is very critical for any business. So that means even for a small business, just have something that helps you to follow when such circumstances happen. For big companies, if you already have it, make sure it is, like we said in the last episode, make sure that those documents are up to date, because some of them, they still bear things that were happening in the past. So like we did mention earlier on, once you suspect that something or this employee has done something, you need to now sit down and now look at what is the charge that needs to be raised and who should raise this charge. A lot of times there's a lot of excitement, a lot of emotions. It's important to remove emotions. Yes. Extremely important, because what happens, emotions will crowd your judgment. And when now looking at the charge to be raised, after you, of course, you have suspected someone, you've done the investigation, it's important that these charges will be linked to your disciplinary code. Okay? Now, I'm talking about the raising of charges because sometimes this is where problems start. And that's why for the HR practitioners, for instance, it's important that they understand what should they do. The area processes we talked about of suspecting someone, then moving to investigation, then where you can come and raise a charge. Here, this part of investigation is very important, because what starts to happen is, if you don't carry out your investigation, you'll find that someone is being framed, for instance. Okay? Sometimes it's just personal. Supervisor just says, I don't want this guy. There are situations where, because you haven't taken time, the supervisor just says, I'm raising a charge here, which is at this stage. I'm raising a charge, I need this person fired. But you have not taken time to actually discuss with them what exactly is going on. Sometimes you find that it's outside issues that are being brought into the company. Yes. Okay? A supervisor, for instance, is... We've picked it. You understand what it is? It's on TV, so... Yes. But these are things we've dealt with in the past. Where something personal outside is happening, and they because now this one is a boss, they come. They tell you, no, this one has to be fired. You can't. Oh, no. Okay. As a HR, you need to now sit down. Okay, so you are saying this one can't work. Please let me know. Let's go through. What exactly did you tell them that they have failed to do? Yes. Okay? Because you want to rule out any other factors around the charges that will be raised, so that when you are raising the charges, they are very specific. Sometimes a person can commit so many offenses. They were doing so many other things to a point where you can't tell head from tail. But it's important again to take your time at that point and say, what exactly are we raising the charge for here? Because once you raise a charge which is not supported, then you are going to have a case where everything falls as you are trying to deal with that case. So at the time of raising the charge, for me, it's important that you take your time, that you make sure you are raising the right charge, and also you make sure you separate, is it a performance issue, is it a behavioral issue, what is this? Because sometimes we see charges, it's a combination of all sorts of things. That day, I gave you work, you can't deliver, and you have been coming late, and after all, the other day, what's the charge here? Yes. You can't combine so many things, and that's why if there's need and there's really an issue, start separating these issues. Because you can find that just like in court, a person can be found not guilty on 2, 3 charges, and they're only found guilty on 1. Okay? So if you start using emotions, and that's why we say suspecting that the person has done something, investigate, then you can come now to the point of raising the charges. And as we've said, charges need to be raised by the right person. And that means if a supervisor or if the CEO or the owner of the business found someone doing something wrong, they should then tell the supervisor or that person to look into the matter, investigate, and then raise the appropriate charge. There are companies where even supervisors, because they want to be seen like they're angels, they are very nice, you see me, I don't have a problem, so they always tell HR, HR, raise the charge. And now as HR also, we want to feel very important. What are you doing? Why are you the one raising the charge? You're not the supervisor of the person. So again, these are things that are happening in a lot of businesses. Because people don't take time to understand things. So now you're HR, you forget that your own disciplinary code says you're going to be their advisor.
Yes.
Now because of pressure which was coming and you went ahead and raised the charge. Yes. What are you doing? Because at that point now you have raised the charge, you are no longer the advisor, which your disciplinary code says you shall be the one to compile the case reports, and now you are stuck. He already mentioned procedural matters. So it's important that, like we've emphasized, remove emotions. A supervisor needs to know when it is their responsibility, if that's what the disciplinary, unless the disciplinary code doesn't say so. But the charging officer will be the supervisor. Because they should be first, that's why they are paid. You have to take responsibility, Because you have some supervisors and managers who always want to be seen to be, I'm very nice. This is business. Business in business. So it's important, first of all, if you are sitting in a place where you're in a supervisory position or manager, also understand those processes. The HR within the company can do the training, or sometimes they can bring in the external consultants to come and train the managers so that they fully understand responsibilities. Okay? Now, when those charges were raised, and as we said, the investigations have been done and you're raising the charge, in terms of procedure, when the charges are raised and the person has been given an opportunity, during the hearing, again, it's important that that committee is seen to be independent. Now, during the time that the person comes for the hearing, again, something sometimes funny happens. You find our colleagues, the lawyers, because in the disciplinary code, which we are talking about, provides for the employee to be accompanied or represented. We talked about these things. The disciplinary code needs to be very clear. Who can accompany the employee? If, for instance, there is a union, the union member or union leadership can accompany the person. Now we are saying accompany. And the disciplinary code needs to be very clear about what will be the responsibility of that person accompanying this employee who is accused of doing something. So that in the hearing, the person should explain or exculpate themselves. They are not being represented by the union. Now you have the union now speaking on behalf. Or you find like we said, a person brings their lawyers. So this is not an external matter, it's an internal matter where you have the employee and the employer. There are two parties to the contract. So when such things happen, the employer should say, boss,
it's not yet your time.
Wait for us outside. and because we've dealt with these kind of cases and the person, no. If the employee wants to be represented by the lawyer, they should first of all wait until they are fired, or they should resign. There should be a separation. The employer and the employee should separate. Then they can nicely be represented by their counsel. And even employers, you cannot start entertaining external counsel coming. And they are, no, we are who are you representing? They should not be entertained to that unless they are really serious legal circumstances allowing for that.
Yes.
So Otherwise, the employer should deal with the employee. And during the hearing, again, the committee should know what it is doing. As we did mention, the importance of that is that these committees sometimes, again, they start not to be objective. He had mentioned this. If you remove objectivity as a disciplinary committee, you should know that you're setting up the company for failure and you are going to lose the case in court later on. That's why we emphasize that even the disciplinary committee, in case they don't know what they should be doing, they can bring on board the consultant, they can train them, or the HR within the company should train them and tell them, what is it that you'll be looking at? It's the facts before them. And sometimes the committee also sometimes is compromised. They start making decisions that are in favor of the employee because they are seeing themselves as employees. Guys, you know, if we fire this one, it will be next, it will be you. Anyway, why now are you now trying to... It's the facts before you.
Yes.
It's nothing personal. You understand? The committee should be very straightforward in the way they are doing things. They shouldn't be taking sides. They shouldn't be taking the side of the employer or the side of the employee. They should be looking at the facts before them and now find that person either guilty or not guilty. And not saying, no, but if you fire this one, you know, he's my neighbor. Oh, we belong to the same church. Oh, we are also part of the same political party. That shouldn't be the case. No. And remember, that committee also is very important because if you allow a person who should be dismissed to stay, or because of some connections or something you're fearing as a committee, what have you done? You have started killing the entire company side because now you have created a certain culture. And the company should also come, because if you didn't dismiss someone who needed to be dismissed, and I said needed to, based on your disciplinary code and based on the facts before you, and you allow them to continue, we are not saying that they cannot be pardoned, but that's a different issue. But to fear to dismiss an employee because of all these connections, what you have done is you create this monster in the company where now tomorrow another person will do the same. They will steal, they will behave in that same manner. And now what are you going to do? Because you created precedents. You say this is okay in our company. So that's why these things are very, very important that the committee does its work objectively without consideration to anything and look at the facts before them. Then they make a decision. Then the person will be communicated to afterwards through HR. And in the communication, it is need to be very clear now to say, you have been dismissed and your last day of work will be this day. Yes. And following this dismissal, the company shall pay for any outstanding salaries. The company will pay any outstanding leave days. If they are on fixed-term contracts, long-term contracts, they will be paid your gratuity. Any contributions to any special schemes and whatever it is. The letter needs to be very clear in terms of what the employee will be paid as well as when they will be paid, which should be on their last day of work. But also in that same letter, it should be clear that the employee has the right to appeal. Again, go back to the document, the disciplinary code. If it says appeal within 5 days or 10 days or 14 days or 21 days, it needs to be clear in that letter that is being sent to the employee so that the employee can now exercise their right. And in the same dismissal letter, it should also be clear who they should appeal to and the format and anything so that the employee who's being let go of can know. And then afterwards, you make sure that within 4 days, this is what the law says, within 4 days, you get the report and as a company and submit to the labor office. This is why we say, if you have done your processes properly, and the person even comes, then I'll take you to court. We even say, do you need the transport? Because you have done all the processes. And labor office is also informed. So there shouldn't be things being done under the table. Things should be clear, and remember the key issue is the reasonableness. Whatever decisions you're coming up with in line with your disciplinary code and all the required provisions of the law, it's reasonable, meaning that any other person can also arrive at a similar decision as yourself.
Time seems to be not with us. And the conversation is
keep on, yes.
Love it to keep on going. Yes. But maybe we can just read 2 or 3 text messages from our viewers.
Okay.
So this one says, please tell Labour go around, tell people about labor, tell people to pay labor fees. Okay? Then this one, good afternoon, enjoying the program, thank you so much. Each employee has 24 leave days in a year, but what of if you don't go on leave? The company says you forfeit those days. How can you claim your days? Well, such an amazing question. Good afternoon, I'm following the program. Sorry, I kindly ask for the number from the labor. Please will respond to this. Mr. K asking, is it right for a company to hold someone's leave days for 5 years, then it will pay when the person retire? What? Well, then, Ishina and Elijah, I'm from Ndola. I have a problem. I was working for Aviv in Chilabombo without a summary or warning letter. I need your help, please. And salary, okay. I think I have to learn how to read it in paper. Inasmuch as the disciplinary code is not punitive, what role does the organization have in ensuring that HR sits down with its employees to ensure that the disciplinary code is well understood by employees rather than changing them based on their ignorance? Share your advice and comments, please. Alright, so we can talk one or two as we wrap up the show, Mr. Kabanda.
So I think in the interest of time, what we can advise all the viewers, if you have an issue or you are dismissed or there was something that actually happened, key to it is put together your documents and anything that can help labor and submit to the labor office in the district where the person is. It's much easier that way. Otherwise, all the other questions that we have also received, we will forward to them for their consideration, and then they can be getting back. For the other ones, we'll try and tackle them in the next episode.
Mr. Stanford, your last remarks.
For me, is objectivity in handling of disciplinary matters for both parties must be maintained. Right. Thank you.
Thank you very much. Well, this has been an amazing conversation. We're looking at summary dismissal part 2. Last week we did talk about it, and this week, today, we did talk about the summary dismissal. Make sure you join us next week, same time, same place. But if you just joined us, you can also go on our Facebook page, which is KBN TV, and do follow the conversation. My name is Patricia Chilamdikoa. Good afternoon.